are in listen-only mode.
Hello everyone, and thank you for joining us for today's educational webinar. We're going to wait for just about 2 minutes to allow some additional attendees to join us. So please stand by and we'll get started in about 2 minutes. If you've just joined us, we're going to get started here momentarily. We're allowing about another minute for some folks to join us for today's webinar. Please hold. All right, let's get started. I want to welcome everyone and thank you for taking time out of your schedule to join us for today's continuing educational series brought to you by Access and Kaizen InfoSource. Let's go to the next slide. My name is Mike Schwab from Access, and again, welcome to our online education series, which is hosted by Access and Kaizen InfoSource. As we've mentioned in past webinars, our goal is to make select topics that are timely, relevant, and in response to our clients' needs. And our goal is to make these relatively short in duration and very focused on the topic at hand. I want to let everybody know that a video of this presentation will be available tomorrow on both the Access and Kaizen websites. And we'll remind you later on, but it's important, and we urge you to please participate in the post-call survey today to help us plan future presentations. I'd like to introduce or ask Pilar McAdam to introduce herself. Pilar?
Hello, Mike, and everyone on the call. My name is Pilar McAdam. I work with Kaizen InfoSource. We're an information management consulting firm dedicated to making you and your information management program successful. I've been working for more than 30 years with a variety of business support records and records processes in both the corporate and the legal environments, and I've tried to focus on the ways that organizations create, use, and maintain information, as well as trying to improve the processes and systems so that the data is more useful and accessible to those who need it. Today we're going to take a look at why it is that law firms really do need retention schedules, what the types of schedules are that law firms need, and that's going to be both the firm business information and the bigger issue of client documents and information. What we're hoping that you take away from today's session are, number one, that having a retention program at your law firm can reduce both your costs and your risks. that the biggest issue you will grapple with is the volume of client information, and the reason that's a big issue is not just because of how much it is, but because you cannot dispose of anything without the client's agreement. And finally, that the best way to get the client's agreement is at the time you are engaged, not later. Having a retention program in place at your firm, number one, demonstrates compliance with the Bar Association's ethical guidelines for attorneys. It will also serve to reduce storage costs. It certainly shows a defensible, consistent process that is being carried out in the normal course of business, which can become critical if your firm is ever sued and you end up in court. It certainly makes e-discovery much more efficient and cost-effective, and it demonstrates to your clients that you as a firm understand what the costs are of using and retaining information. There are two schedules. One is going to deal with your firm's business information and the other with the client. Your firm's business information are those documents and collections of data that deal with the day-to-day operations of your firm, your human resources, what goes on in accounting and finance, facilities and equipment, client development, internal projects such as IT, software implementations, and general administration, the insurance that your firm carries, purchasing, things like that. There are very few external rules on how long you have to keep that stuff. Law firms kind of operate in a little bit of a unique way because for the most part, they're privately held. There will be some labor laws because your firm has employees, and of course you'll want to comply with tax regulations. But other than that, you're really free to develop the business retention requirements that you need to meet the needs of your firm. Client information, however, is another ball of wax. The American Bar Association has a section 1.15 that deals with the obligation for attorneys to provide safekeeping for client property. That information is everything that is collected, created, used during the client's engagement until that closes. The only exception is going to be the business intake information, such as intake forms, internal conflict checks, the engagement letters between you and your clients. For the most part, those are not included in what belongs to the client. However, this can vary from state to state. So if you're not aware of what your state's Bar Association guidelines are on this topic, talk with your risk attorney. How many times can I stress this? The client's information is the property of the client. It does not belong to the firm. You cannot destroy that client information without that client's permission. It violates the attorney's ethical obligation. The only alternative to getting their permission to destroy it is to send it back to them. How on earth do you get rid of the stuff when you want to? Okay? All right, the hard way, and in my experience this is the way most firms try to deal with it, is they take a look at all their old stuff years after the matters have been closed, and then they try to track down the client to get their permission. The lucky ones are the ones that actually find the client and get them to respond. In most cases, this is a real administrative headache. Oftentimes those clients no longer exist, or they don't respond. There is an easier way, and that is for your firm to establish a retention policy, such as some number of years after the matter is closed, and incorporate it into your engagement letters. That way, when the client signs the engagement letter, they are agreeing to your retention policy, and you do not have to go back to them again. At the time that the information is eligible to be destroyed, you can proceed with your disposition. But wait, there's an even easier way to do it, and this is actually in effect at some firms, and that is to return all client information to the client when your engagement is over. That, of course, will need to go into the engagement letter and be signed off by them so that you know how to operate when the matter closes. Any decisions about when to dispose of information, whether it's the firm's or the client's, is going to involve some risk to your firm. Your firm will have some risk management representative. It may be your general counsel, it may be a professional conduct committee, a risk partner, etc. That individual or committee needs to be involved in the development of your policies, to endorse them, and to be willing to stand up for you if anyone ever questions them. Also remember that regardless of what your retention policy is, you cannot dispose of any information, whether it's the client's or your firm's, if it's subject to a litigation hold. That litigation hold may come from a client, so they may be being sued and they're asking you to hold on to their stuff, or it may be because your firm is unlucky enough to be being sued and you need to hold on to it for your own defense. This also applies even before that litigation hold is issued if you have reason to believe that litigation will happen. And now I'm going to turn it back over to Mike Schwab. Mike, are you on mute any chance?
Yeah, I'm here. Thanks,
Okay.
Pilar. So when you consider some of the items that have been discussed in terms of a program, I think a very important consideration is to simply not avoid the decision to set up a retention program. Certainly from our perspective, we've seen that mistake made, and the fact of the matter is, with some effort, with support from risk or professional standards or conduct, you can develop a sustainable program, and it needs to happen. And if you do so, if you establish that comprehensive program, you'll gain that peace of mind that you've done all you can to mitigate risk and be compliant. And I think it's also important to note that choosing the right service partners will help you support an internal program. For many law firms, it's one thing to create the retention policy and the systems and the team to support it. But the fact of the matter is, most law firms, depending on the size, are reliant in using an off-site records management partner. And we believe that the firm's policies, procedures, systems, strategies are truly integrated and need to be in step with a records management service provider. It's one thing to look at a service provider as simply an off-site storage center where the boxes go, but the real successful programs integrate and partner tightly with a partner so that both parties can support the program. I'd like to share with you a client opinion. Access is fortunate to work with Perkins Coie. Perkins Coie is a national law firm headquartered in Seattle, Washington, and currently has more than 900 attorneys in 19 offices across the United States and Asia. Patrick Benedict is Perkins Coie's Director of Records Management Services, and here's what Patrick has to say about Access. My advice to firms considering a change would be simply do it. The Access team is top-notch and will walk you through the process regardless of how many or how complex the project may seem. I'm extremely satisfied with the move to Access and only wish we would have done it sooner. So the combination of Access as a support partner, a records management provider, along with Kaizen from a professional services partner, I think is very powerful. We'd invite you to give us a call here at the toll-free number to learn more about our relationships that we have with legal clients and discuss your requirements. So next up in our education series, we've got a presentation scheduled for Thursday, September 26th at 11 a.m. Pacific time. And we're going to really drill down deeper into the topic of retention schedules. And the fact of the matter is the team at Kaizen has been instrumental in terms of developing retention policy and formal retention schedules over many, many years. And we're prepared to share with you some of the lessons learned, the lessons that no one teaches you about retention schedules. So, as I mentioned at the onset, please help us improve the content of our webinars. We do ask that you complete the post-call survey that will be automatically presented to you as we end the session. Your answers, comments, and suggestions on what you would like to see us include in this series will translate into more valuable future presentations, and we hope it will contribute to your professional growth. I will say that we've had some good feedback over the past couple of months, and we've taken note of some of the feedback, and we've utilized it, but we look forward to hearing from you and learning even more. All right, let's take a moment here. I know we have, looks like we've got a couple questions. So before we wrap up, let's take those questions. Pat?
Sure, thank you, Mike. There is a question here. There's actually quite a few. I have one from Lydia. What is a litigation hold? Was the question.
Okay, and this is Pilar. I'll jump in on that one. A litigation hold is what's put into place when someone is being sued and there's a requirement to freeze any records that may be pertinent to that lawsuit. There'll be usually a subpoena for records. That may be the first notification that an organization has, and it will be very detailed, or hopefully detailed, on what types of records it's looking for, what's pertinent to that lawsuit. All of those records need to be suspended from any destruction, and they need to stay suspended as long as that litigation is going on. So only upon successful conclusion of the lawsuit can the retention schedule be reactivated.
Okay. Next question. What about clients who have their own rules for retention? We have clients who won't sign our engagement letters, but ask us to sign their outside counsel guidelines instead?
Okay. If your firm has signed the client's outside counsel guidelines, those will trump whatever is in your firm's engagement letter. Sometimes those outside counsel guidelines will include retention instructions, other times they will not. If they do not, you'll have to negotiate with that client to determine how you're going to deal with retention. Anyway, but their rules trump yours.
Okay, next question. Is it better to destroy client records at the storage company or to bring them back to the firm?
That's a good one. I will say it's going to depend on how well controlled your firm's processes are to make sure you know exactly what is inside those boxes. If your firm has good detailed indexes of all the box contents, and if you enforce processes that ensure that any changes to those contents will always update the index, and I know it's a long list, and if a box contains documents that are all subject to the same retention. So for instance, everything in that box is eligible for destruction in the year 2016. Okay? If all of those conditions are met, and I'll add, if you're dealing with a reputable storage company who has bonded employees, okay, then I think it's fine to allow the storage company to do your destruction for you. Okay? But you can tell from the list of conditions that I've just given, in my experience, most law firms do not have that level of control of what's inside a box. Therefore, if you do not have good control of what's inside the box, I think you should bring the contents back to your firm and do the destruction at your firm.
Okay. Next question. Oh, go ahead.
Yeah, this is Mike. What I would add that this is an example of having that lockstep or that good integration between your law firm and your internal policy and the process from your records management or record storage partner, so that there's a very clear protocol, and that can be managed by virtue of the process that's set up for sending new boxes offsite. In our case, the use of the Access online system, the file line access system, where there's an understanding on what fields might be populated to describe the contents of the box or a destruction review date prior to it being sent to the record center. We've seen a lot of law firms that are in that position where they've got boxes in storage and absolutely don't know the contents. In those cases, we try to work with those clients and look at a process for a review. But even if you have that trailing history of some unknowns, you can take some corrective steps to make sure that you and your offsite partner have conceived a smart process going forward.
Thank you, Mike. Next question. Excuse me. We don't have any retention agreements with our clients, so we have to try to locate a client to get permission to destroy their documents. When a client no longer exists, how can destruction be authorized? Do we have to retain that stuff forever?
I wish that situation were uncommon, but it's not. Honestly, you need to work with your general counsel, your risk partner, to come up with a some kind of strategy that will work for your firm. So how much risk are they willing to tolerate? There's always going to be some risk, but your general counsel may be willing to set some boundaries. An example, and this is only an example, okay, of such a boundary might be if you've tried to contact the client, you can prove they no longer exist, and if the documents are for, say, a litigation matter that has been closed more than 20 years. The general counsel may be willing to say, you know, under that condition, go ahead and destroy it. So that's an example of something that you may be able to negotiate with your risk partner.
Thanks, Pilar. Are there any more questions? Okay, I do not see that there are. Okay, Pilar and Mike, that's it. There's no more questions.
Okay. You know, I would add one more thing, since I think there, you know, we've talked about the development of retention policy, and then there's the execution of the program. One of the benefits that Pilar cited was a reduction in long-term or ongoing storage fees or costs. And just want to emphasize that if you're an Access client today, we'd be happy to work with you to look at ways to help you implement and actually, you know, act on your retention policy and begin to destroy some boxes. We very much believe in the life cycle management from a records perspective, and so we're here to help and talk about ways that we might be able to assist. With that, I think we're just about at the bottom of the hour. Again, I want to urge you to please, if you will, respond to the post-webinar survey. As was mentioned already, we also have our next session, which will be the lessons learned in developing a retention schedule. And of course, that's scheduled in September. And so we hope to have you all back for that session. Thanks, everybody, and have a great day.